So the legal position is that whoever purchased the pet is the legal owner. So whoever made that initial payment for the pet in the first place is the person who has legal ownership and beneficial ownership. However, if the purchaser then transfers ownership by way of a gift to the other person, then that does transfer legal ownership and beneficial ownership. However, you would need to be able to prove that a gift took place, and the burden of doing that falls on the person that's saying that a gift took place. But obviously, it's extremely challenging and difficult to provide evidence because when you receive a gift, you don't tend to retain any evidence of it. But so therefore, it's imperative that you do, if you are going to receive a gift of a pet, you try and keep the evidence, and evidence could be a card, a social media post, or a text message. But it's important to note that a text message between you and a third party discussing the gift would not be classed as concrete evidence that a gift took place. It has to be from the person that is gifting you the gift. With regards to registrations, such as the microchip, the vet registration, the insurance registration of a pet, this doesn't determine legal ownership. They're considered secondary factors. So a court will more likely look at the registrations of a pet if they've concluded that a pet has been purchased by both parties jointly, and then that therefore becomes more relevant. However, courts are quite black and white and quite insensitive when it comes to determining who owned the pet. They don't tend to care who cared for the pet, who adhered to their needs more so. It's primarily who purchased the pet in the first place by making that initial payment.